I'm Nick Snow, watching Government for Oil and Gas Journal in Washington, D.C. To settle or not to settle, that is the question. Whether it's practical or simply expedient for a federal agency facing legal action to negotiate a compromise so it can use increasingly scarce resources elsewhere is hardly a Shakespearean dilemma. It is a growing problem. The U.S. Chamber of Commerce called this sue and settle process, quote, regulating behind closed doors, end quote, in a new report. The process also excludes industries and other affected parties until the settlement is final. We did this report because sue and settle shuts the business community out of the regulatory process, Chamber Senior Vice President William L. Kovacs said on May 20th. Agencies do not maintain a centralized database, he continued. They would not provide information to Congress, even upon request. Once they begin to negotiate, they agree to be under court supervision of a process driven by private parties. The report cited 10 costly regulations resulting from sue and settle agreements. Number 3 on the list was the U.S. Environmental Protection Agency's August 16, 2012 requirement that the oil and gas industry use maximum available control technology to limit well site emissions. It is expected to cost producers up to $738 million a year. EPA developed the regulation after settling a January 2009 lawsuit by environmental groups. It agreed the following December to update its new source performance standards for oil and gas drilling, its oil and gas MACT standard, and the air toxics, quote, residual risk, end quote, standards, the report said. There are about 117 rules from such settlements, some of which are multiple requirements from one order, Kovacs said. To add insult to injury, prevailing parties' attorney fees are usually paid. Successful project-specific challenges let environmental groups build a record to oppose other permit applications, noted Clara M. Poffenberger, a partner in Bingham McCutcheon LLP's Washington office. By agreeing to a settlement, court-ordered or otherwise, EPA is conceding its authority to establish standards, she said. The problem also has reached the U.S. Fish and Wildlife Service. As more non-governmental organizations become interested in the Endangered Species Act, it's being used to drive polar bear protection and other broad policies, said Michael B. Wigmore, another Bingham McCutcheon partner. A possible mega-settlement to address the backlog of 251 species on FWS's ESA candidate list would affect businesses beyond extractive industries, he warned. We're seeing consent decrees used to limit not just current, but future administrations, Wigmore said. The Chamber supports 2 bills, H.R. 1493 and S. 714, which would require a 60-day public comment period before a settlement became final. It also has begun to catalog such cases. We're basically doing the federal government's work, Kovacs said. That's Watching Government for this week. In Washington, I'm Nick Snow for Oil and Gas Journal.